All rise. The Court of Appeal in for the 50th State of Florida is now in session. The Honorable Carrie I. Evander, Judge, presiding. All persons having business before the court shall near you within 10 will be heard. God save the United States of America, State of Florida, and this honorable court. Please be seated.
Okay, good morning, and welcome to a session of oral arguments at the 5th District Court of Appeal. Let me go ahead and introduce the other panel members. Seated to my right is Judge James Edwards, and to my left we're pleased to have as a senior judge sitting with us Judge Bruce Jacobus, who's filling in because of a recent appointment of one of our members to the Supreme Court. We have two cases on the docket. Both of them are civil cases, so each side will have 20 minutes apiece. If the appellant lets me know how much time they want to reserve for rebuttal, I'll try to assist you in that regard. Make sure you turn off any electronic devices so the attorneys are not disturbed during oral argument. We will take about a 10-minute break between the first and second to meet with the attorneys if they wish to join us for coffee in the attorney lounge. First case will be Thompson versus AVILA.
May it please the court. Karen Bellis with Kubicki Draper for the appellant and cross appellee Mark Thompson. I don't know how you would like to handle. I don't know how you'd like to handle the cross appeal, but I would just like to reserve 5 minutes for rebuttal and split my time.
Why don't you go ahead if you wish. You can address the cross appeal in your argument.
Perfect. So to begin, in this case, the trial court recognized that the jury's verdict was excessive, influenced by matters outside of the record.
What were those matters outside the record, do you think?
I think that clearly they were not happy with the various things that occurred at trial, such that they awarded a 1.3, almost 1.4 award for pain and suffering when there was absolutely no evidence whatsoever that the plaintiff would have any future award, any future medical damages, or suffer pain in the future.
It seems as though he'd had every possible medical treatment you could get up to the time of the trial. He did. He had surgery. Unfortunately, that occurred, and if liability is to be believed and causation is to be believed here, he had surgeries that pretty much left him doing very, very well. He had replacement disc surgery. He could function fully. He could work as much as 7 days a week, 10 days a week, lift. He had gone through several surgeries where he was in pain and left with no pain. Well, that's not exactly right. He did say he had pain, didn't he?
He had minimal pain, 2 to 3 aches and pain after a long day doing hard labor.
Carried medicine with him all the time, though, did he not?
He carried Advil
Right.
to deal with, but again, Advil and $1.4 million, there was absolutely no evidence, and as the trial court found, the award of
Didn't the jury get to see and hear all that? They heard about his surgeries, they heard all the things that happened to him, they saw him. Isn't that what juries do?
That's what juries do, but juries cannot award damages that are unsupported by the evidence.
So the number's too high, is what you're saying, for pain and suffering?
Clearly, the number at a minimum is too high for pain and suffering, and as the trial court found, it was unsupported by the evidence. There was no evidence, documentary or testimonial presented.
Did the defense ask for something? Did they talk about future damages, future pain and suffering? Did they put a number on it at all?
Well, the defense put first a liability defense forward, and
That's
the jury.
pretty much what the defense was, wasn't it? Liability.
Well, the defense was liability, causation, pre-existing, herniation. We had medical experts to testify that the injuries were degenerative.
Did the defense suggest a number to the jury for future pain and suffering?
The jury did not suggest a specific number. The defense did not suggest a specific number. The defense suggested that at most 33%, and suggested, I believe, as to future pain and suffering, that he would have no or a nominal amount of future pain and suffering. Because, and again, if you look at page 19 of our initial brief, yes, if you believe causation and that liability was the fault of the defendant, there are past medicals, and there was a range, and the defense suggested that the medicals that were awarded were too high and the charge was too high, but the past was that he had pain injections, he had neck surgery, he had surgery, but the future prognosis was not that this man was unable to obtain anyone recommended anything in the future where he would need to undergo any future surgery or even have any medical care. There was no future medical expenses requested. It's undisputed that he missed no time from work other than when he needed to recuperate. He was able to perform his job, including heavy labor, that the result was great. Look at Dr. Greenberg's testimony, the plaintiff's own doctor.
The defense thought $250,000 even was too high.
Correct, because a nominal amount or a minimal amount, something for having to take Advil. I mean, unfortunately, even we sitting at our desks sometimes have to take Advil, but that doesn't warrant $1.4 million.
No, but I mean, the defense thought even $250,000 was too high.
Correct, which is why we are at a minimum requesting that the trial judge's grant of a new trial on future pain and suffering is minimally correct, but we rejected the remitter to $250,000 because what should be awarded is some nominal amount, which would leave us in the position of having to have a new trial on future pain and suffering only.
What was his life expectancy, like 38 years?
38 years, but here's what's interesting. Again, the past, he had surgery, he had healed, he was well functioning, he had some aches and pains, he had a heavy labor-intensive job. No one recommended, this wasn't the case, and I may be jumping ahead of myself, but I know that my opponent has made the argument that he couldn't get any more medical treatment.
Let me ask you this. Given a 38-year life expectancy, if the jury accepted his testimony that his pain before this collision was 0, and that after, on a scale of 1 to 10, it was a 2, is your position that, even if you go 38 years with a pain level of 2 rather than 0, that it should be nominal damages or no damages?
It is, but there are a couple parts to that.
What's wrong in my question? What is not supported by the evidence?
What is not supported by the evidence is the following. The jury did not believe, and there was no testimony, that his pain was equal for the past and the future. Instead, there were about 4 years, and the 38 years in the past and the pain, I'm getting to answer your question. The past pain and suffering, where this gentleman underwent 2 surgeries, including a time where he had to
I'm talking about before the collision.
Before the collision, if the jury were to believe there was nothing, the testimony was that his pain was excessive. It was a 10. He had to go to surgery and then have another 3 disc replacement, if you believe liability, that it was so intense that he underwent surgery where he had a tube placed in his mouth, where he then underwent recovery from that surgery, had the disc replacement. That period of time was about 4 years. This isn't a case where the jury awarded no money or all of the money is being taken away by the remitter if the remitter stands. Instead, what happened was, for the past, the jury awarded approximately $176,000 for this intense pain of being operated on, being cut open, on having surgery, and having testimony of very extensive pain. The jury awarded, the number I believe, I have it written down here, is $35,247 for the past 4 years where this man was operated on. If you look at the testimony for the future, he said he was in horrible pain. He then went through surgery and recovery. His doctors, and only the plaintiff says he has any pain in the future. His doctors said there's nothing more because everything is functioning well. Just like every other 40-year-old person, unfortunately, you're going to have some aches and pains. And in the future, they suggested surgery. They suggested he might have to take some Advil. He came to the doctor coincidentally right before the eve of trial after having almost 2 years of no treatment, and had simply a referral to a pain management doctor. No recommendation of surgery.
But
Yet, they award,
yeah, I understand, you still haven't answered my question, though. I mean, what you're saying in that 4-year period is you had a pain level of 7 or 8, and afterwards you had a 2. My question was, before the collision, he had a 0, and if you accept his testimony that after all his surgeries and all, for the future, he had a pain level of 2, you're saying it should be nominal damages only. I'm trying to, understand that argument if the jury accepts his testimony.
And let me
But,
tell-
if you
and
have
perhaps
pain for 38 years that you didn't have before the collision.
it's not worth $1.4 million.
Well, I understand that argument, but that's a different,
But
that's a different statement
And I'm
than,
trying to kind of get to why maybe I'm being long-winded. The past with the surgery and the terrible pain, $32,750 per year is what's awarded for pain and suffering. Now, the doctors say he's well healed. He can function fully. He may have some aches and pains, but we all do. They award the jury awards the exact same number if you do the math. 35, and this is in our brief, $247 per year for the next 38 years of his life, when he is not going to have, and no one testified that he will have any medical treatment, any surgery, or any pain. A pain of a 2 is not worth, if that's what it is and you believe it, and
But the
even,
jury thought it was.
and as the trial court
I mean,
found,
and isn't that, that's an intangible thing. And generally, we leave it up to them to decide that.
it is usually left up to the jury. However, where the trial court, as he did here, found that that was not supported by any evidence, especially where there was no testimony that he would have any medical treatment in the future that was similar at all to that in the past. The trial court found that he cannot even begin to understand how the jury arrived at the award of almost $4 million. It is more than 5 times the amount supported by the evidence, shocks the court's conscience, and the amount is that which the court finds anyone would find is shocking. And if we move simply to the standard of review on that, a remediator is clothed with wide discretion, is not to be reversed unless there is a clear abuse of discretion.
But don't you
unless-
claim that there was a clear abuse of discretion when you don't accept the $250,000 remediator yourself?
A clear abuse of discretion,
In awarding, in other words, the trial judge did 2 things. She said, I'll remit it down to $250,000. If you stop there and look at it, that's entitled to the same standard of review, isn't it, as then granting the new trial as a conditional alternative?
well, the remediator does 2 things. It gives an option. Either you accept the remediator or a new trial, and the order says so. And that portion, no, is not an abuse of discretion, and reasonable men could differ, and therefore, that portion, at a minimum, must be affirmed.
The $250,000.
The new trial, if the parties reject.
What about the $250,000? Is it also entitled to the clear abuse of discretion?
Well, a judge
standard?
can't just grant a remediator. By statute, it's a remediator or a new trial on a minimum of that element of damage, and that's what the judge did. So that portion was not an abuse of discretion in saying that at a minimum, if you guys don't like this number, which we think is too high, and they think is too low, then there's a new trial. And that is the portion of the verdict that cannot be disturbed. It is clothed with presumption of...
Why isn't that being a 7th juror? Why isn't the trial judge being a 7th juror in this case?
The trial judge isn't a 7th juror when
Well,
he finds that there is no
the number's too high. It
evidence.
shocks my conscience. I mean, really.
Well, then there could never be a remediator if the judge wasn't allowed to observe the evidence and determine that you cannot award the past exactly the same as the future per year, where there's no testimony whatsoever that this man is not healed, is not having a remarkable recovery, and will not need any future medical treatment based on this injury.
let me ask you this. You also, you say there should be a new trial in its entirety if the judge set aside, found that the amount awarded for future pain and suffering was not supported by the evidence. What's the standard of review for us as far as the trial court's decision to only grant a new trial based on after the rejection of the remediator on the future pain and suffering, as opposed to not granting a new trial in its entirety? Is that abuse of discretion
It
as
is
well?
abuse of discretion. The standard to reverse a remediator is higher. It is extremely great abuse of discretion, then the standard for not granting a new trial is abuse of discretion as well. However, since the decision in Special versus Boca, unless the opposing side or the beneficiary of the error can prove that the other errors did not affect the jury or the verdict, a new trial is warranted. And our argument is, at a minimum, the trial court was correct in reducing or granting a new trial on the future pain and suffering. But when you look at the excessiveness of that verdict, then you combine it with the various errors that occurred, that there was no way to prove that the errors that led to the excessive pain and suffering verdict did not also bleed into the other areas.
Didn't the trial judge find specifically that it only affected that and did not spill over?
The trial judge did disagree with our position and find that the other errors did not warrant a full new trial, and that only a new trial was warranted on.
And the other awards, are you contending that any of them were not supported by the evidence?
We are, and we are because of the exclusion of testimony, the improper admission of surprise testimony on the medical damages. by
Well, the
Dr.
medical
Reuter.
bills, the bills came in evidence, right?
The bills did come
And the
in.
jury gave what the bills were.
Correct.
So there was evidence to support it.
There was evidence to support it, but
Okay.
we believe that the taint, the error bled into the jury's determination on liability, not awarding any liability on the red car, and therefore...
Liability was clearly contested. I mean, the
Clearly contested.
plaintiff said there was no vehicle in front of him. Your client said there was, slammed on the brakes, and then a couple of different versions. I mean, the jury was obviously free to accept or reject any part or all. I mean, they're instructed to do that, correct?
The jury is, but given that the jury awarded...
What about the future award tainted? How did that taint the liability picture, though?
Well, there were other errors at trial, and I believe that when combined...
Nothing related to liability, though, was there? They were all damage kind of questions, I thought.
There were a few comments about, by the plaintiff's counsel with regard to the merits of the witness, a hired gun, Dr. Reuter, I believe, that...
Again, that goes to damages, and those words certainly were not used.
Well, the words that were used were shrapnel, and that's it. And in our brief, we frame out a variety of improper comments
The
by...
objection was sustained and no motion for mistrial, correct?
That is correct. However, I believe that if you combine all of the errors and then this excessive damages award, under BOCA, the cumulative effect of the errors would warrant a new trial.
You're at 4:20 now. You want to save the rest of the time for rebuttal?
Please, thank you.
Good morning. May it please the court, I'm Shay Moxon from Brannick and Humphreys. I represent the appellee ALVARO AVILA, and I don't know if it's the court's practice to give rebuttal on cross appeals, so
I think in this case, since she addressed it in large part, I think you could, address your cross appeal now.
all at one time.
Yes.
Yeah. Well, actually, that's what I want to focus my time on. I don't believe the defense has shown any legitimate reason to get a new trial on all issues, and I've addressed their arguments in my brief, and it sounds like the court understands my position on those issues. So,
Well, let me ask you, here's my concern on your cross appeal.
yes, Your Honor.
As far as whether the evidence supports the jury's verdict as far as future pain and suffering. And that is, the testimony from your client set a high pain level for the 4 years or so between the collision and trial. And then set based on your client's testimony, a significantly lower pain level afterwards. And I believe his testimony was 7 to 8 during that 4 years, and afterwards 2, and sometimes at the end of the week up to 4 or 5. And your opposing counsel has argued, and tell me if she's wrong on it, that the per diem or per annual basis for the pain and suffering, the jury appears to have given the same amount. And so that causes me concern, and so I at least understand why the judge may have done what the judge did on the remittiture order. So is there a problem, for your position if that's accurate? First of all, is it accurate?
Well, I looked at I did the math myself, and yes, the annual figures are very close to the same. So I don't dispute that.
So then the argument would be that either the jury undercompensated your client for the 4 years before the trial, or overcompensated them for the 38 years after.
Yes, that's one way to look at it if this type of analysis is really required legally. So even accepting this proposition that the jury has to somehow calibrate its annual amounts, then we would say that just shows that the past amount was just too low, $106,000.
Well, pain and suffering is hard to quantify. I mean,
Yes.
I think we can all agree to that.
Yes. And
But your client did attempt to quantify it based on questions from his counsel, and the jury's verdict does not seem to be consistent with his quantification, if you would.
Well, Your Honor, there really is no legal basis to scrutinize these annual amounts and determine that they're out of proportion, and that would be a reason to set aside the verdict. There's simply nothing in the law that requires it. Courts don't even have to allow attorneys to make per diem arguments. It's discretionary with the court, and there wasn't a per diem argument made in this case. It's simply one method that a jury can use, but as the law says, there's no standard for measuring these damages other than the enlightened conscience of the
But
jury.
if, for instance, you had a plaintiff who broke a small, pinky finger, and the jury gave, $500 million for it, I mean, would we all agree that a judge could say this is an unreasonable award? I mean, at some point, the judge can say this is an unreasonable verdict, right?
Yes, and the limit defined by the law, I think the most objective one it comes out of, I believe, BOULD, B-O-U-L-D. That's when the only time that the amount alone can be reason to set aside the verdict is when it is so inordinately large as to obviously exceed the maximum limit of a reasonable range within which a jury may properly operate. So, there are several fudge words in there that build in extra layers of kind of, if you will, slop and play to give deference to the jury's discretion.
Well, but then on top of that, using your terminology of slop and play, it's hard to imagine a standard higher than not just abuse of discretion, but a clear abuse of discretion before you can set it aside. I mean, you've got a high wall to clear there.
I appreciate that, Your Honor, and yes, I accept that. But that doesn't mean impossible. It happens, and this is one of those cases, because that principle is also in tension with the wide discretion that is given to juries to determine the amounts for non-economic damages. And there are a number of legal principles that have been laid down that limit the court's discretion to interfere with the jury's verdict. The Supreme Court has said how the trial court cannot sit as a seventh juror with veto power over the verdict. It can't declare a verdict excessive just because it's for more than the trial court would have awarded. And when the trial court is going to make findings of passion, prejudice, or improper influences out the record, the trial court has to point to specific things in the record that would support a conclusion like that.
And the other side is the jury's wide-ranging authority is not unbridled, and it's up to the trial court superintendents through post-trial order of remitted to a new trial. I mean, so for every platitude on the one side, there's one on the other. So again, it comes back, the question I really have is, how do you show a clear abuse of discretion when the judge commented, and at least two of us, I'm not sure what Judge Jacobus saw, when you look at the same number per diem, per annum, whatever, before and after, the pain before and the pain after the recovery from surgery, by your client's testimony, wasn't the same, yet the award was.
Well, one other point I wanted to make about that, the trial court never relied on that. That is strictly an argument that the defense made in their motion for a new trial and in their appellate briefs, but the trial court did not rely on that at all as a reason for granting the remittitor. And this court's review has to focus on the reasons that are given in the trial court's order. And that was discussed in the Hawk case and
Well, let me ask you this, if the
And
judge's order is defective, what's the remedy?
well, in this case, it's not merely a defect in the order, but the record simply doesn't support the court's reasons.
Right,
There's,
but my question is, if the judge does not cover all grounds that they're supposed to cover in the order, do we send it back for the judge to see if the judge can cover all grounds, or do we say, Judge, you didn't cover all grounds, and we set aside that? What's the remedy for a defective order? I mean, to me, there's two parts to your argument. One is the trial judge was just wrong substantively,
Yes.
and the other is that the order's defective. So I'm asking you, on the order's defective argument, what is the remedy?
well, the remedy is to reverse and remand with directions to reinstate the verdict and enter judgment on the verdict. And that's because the order is not merely defective, but it simply doesn't have any support in the record. There is nothing in the record to show that this jury was motivated by passion, prejudice, or any considerations outside the record.
So if the judge's order reflects that they didn't refer to a factor they're supposed to refer to in the order, you're saying they don't have another opportunity to address that factor? If we say you addressed these factors, but you didn't address these factors in your order, we don't give the trial judge an opportunity to do that? Is that what you're suggesting?
Well, I don't believe that the court necessarily has to tick off all the possible factors. The analysis is where the court's findings are supported by the record and whether the findings that it did make, or even if there are any legitimate grounds in this record to grant a remediator. And there aren't, because this verdict was supported by the evidence, and it's within the range of awards that juries have awarded for similar injuries in other cases. Mr. Avila, he testified how he has pain every day, that these aren't just typical aches and pains that we get occasionally, that it's pain he has every day. And although 2 or 3 out of 10 sounds like a low amount, we're talking day after day. He's taking maximum strength Tylenol every 4 to 6 hours, and it goes as high as a 5 by the end of the week, which is the worst possible amount you can imagine. I mean, half of the worst possible amount someone can imagine. So the jury's considering how he goes through this every day and how that affects his quality of life. He can't sleep very well. He has to use his TENS unit once or twice a week to be able to sleep. I can go on and on about the evidence supporting it, but also this award was also within the range of other awards that juries have given for cervical injuries. I've discussed the South Bacteria Services case. That's an interesting case because we have the same award for future non-economic damages, $1.3 million. And although there was testimony about a possibility of needing various kinds of medical treatment, the first DCA said, the only medical treatment that was proven to any reasonable certainty was pain medication. That's only going to cost $7,000 over the rest of his life. So subaqueous services, same thing as this case. The only future treatment on the horizon is pain relief. And
He could no longer work on the water. He had depression. He couldn't sleep, not just sometimes, couldn't sleep at all, couldn't play with his grandchild. And I know it's impossible to ever find the cases exactly the same, but I believe in Mr. Corbin, sounds like he wasn't taking a couple of Tylenol or a couple of Advils a day. I mean, he wasn't able to sleep. He wasn't able to work on the water anymore. He talked about things, again, in a range that seemed beyond your client's range.
That's true. That's true, Your Honor. And every case does have distinguishing factors. And I've cited a number of verdict reports in my initial brief because, frankly, there aren't many published decisions out there saying how much is a good award for a cervical disc injury. So I cited about 5 of them, pages 54 to 55, and we see a range from $1 million back in '97, which would be about $1.5 million today, up to $2.9 million in recent years. And those are just awards for future pain and suffering. And yes, every case is a little different. Every case has different factors, but this is a rough analysis because we're just looking at is this a type of award that a jury can award for future pain and suffering in a case like this? And it is. It's supported by the evidence, and it falls in the range of what juries have awarded. So the question, is this award so inordinately large that it obviously exceeds a maximum range in which a jury could operate? No, it's not. This is a legitimate award for this kind of case.
Let me ask you this. You have all these cases that say that a judge is to give a lot of deference to the jury. And then you have, but then on the other side, our standard of review on a remitted order is abuse of discretion. I mean, how do you, I'm having trouble reconciling those two. Because on the one hand it says give a lot of deference to the jury verdict, but then abuse of discretion standard means we're supposed to give a lot of deference to the trial judge.
Well, if I could add a little more to that.
Okay.
Also, a jury is afforded particularly wide discretion to determine non-economic damages.
Right.
Because they're not like medical bills or lost wages, past or future, where you can do a mathematical analysis or where you can look at the record and say, you know, there's absolutely no way the jury could get to this number.
Yeah, but remitted orders, would you agree that most of the case law is going to be about non-economic damages?
Not always.
Your Honor,
I mean, there's some.
respectfully,
But
that has not been my impression. I see a lot of cases reversing awards of future medical expenses because the math didn't add up. And I've seen cases doing the same with past lost wages and loss of future earning capacity. My impression is that these remitters of non-economic damages are very rarely granted, and that when they are frequently reversed. And this is a case that calls for that. And as far as the abuse of discretion analysis, the Supreme Court once said, and it's been repeated in a number of cases, that the trial court's discretion is exercised in the context of determining whether the verdict was against the manifest way of the evidence, which is kind of another phrasing for all these standards I've told you, or whether the jury was motivated by improper considerations. Well, the trial court didn't find any, well, you know, there's a perfunctory finding that, oh, the jury must have been influenced by something outside the evidence, but there's simply nothing supporting that.
Just buzzwords.
There are buzzwords. There are conclusions and buzzwords. And when you look at the real meat of what is in this order, there are just two things. The judge didn't like the amount. Well, that's not enough by itself, and I've discussed how this is really an award that falls within what juries are awarding for these damages in this situation. And the other thing is this lack of evidence of future medical treatment. Well, two problems with that. First, it's not entirely true. Mr. Avila is going to need some kind of treatment to alleviate his pain, whether it's that he continues to take extra strength Tylenol every 46 hours for the rest of his life, whether he goes through with the injections. There is evidence he will need some future medical treatment, but more importantly, it's not a relevant consideration, because future medical expenses are a completely different item of recovery. It's and we see in subaqueous services how you can have minimal future treatment needs but still have continuing pain. That happens when somebody reaches maximum medical improvement, but they're still in pain day after day.
let me ask you, if you have a clean trial and, no evidence to suggest, the jury considered an improper factor as far as evidence per se introduced to trial, and again, going back to, you have a broken little finger and the jury gives $500 million for pain, future pain and suffering, are you suggesting that a judge can't order remitted or by saying that number is just too high?
No, Your Honor. And again, the standard, like I said, the most objective standard that I think has come down is this line from Bold. It has to be so high, inordinately high, as to obviously exceed the maximum limit of a range, a reasonable range, and within which a jury may properly operate.
And the trial judge,
And
that's what the trial judge, right or wrong, determined in her mind, this was inordinately high and no reasonable jury could award that amount. I mean, is that kind of what the trial judge said?
The jury, the trial court used the term shocks the judicial conscience and believes anyone else's conscience would be shocked. Well, based on the evidence presented and the other awards and other cases, that's just not supportable. This is a case where the judge simply disagreed with the amount. He's acting as a seventh juror, exercising veto power over the jury's verdict. And that's when you have an abuse of discretion. When the trial court, instead of staying within his very limited role of determining whether you have a crazy verdict, $500,000 for a broken little finger, instead of
The reason I
staying in
throw it
that
out is
role.
because at some point there has to be a line drawn where you can say a judge can set aside that amount.
Yes, yes. And this isn't that case. This verdict was supported by the evidence, and it's in the line of what juries have awarded in similar cases, recognizing, of course, that every case is different. And to return to a previous question, there are all kinds of cases that when we have a case like this, when the record just doesn't support a remitter, that the remedy is to reverse and remand for entry of judgment on the full verdict. There are Florida Supreme Court cases like Ashcroft, Allred. There's some decisions from this court, Waddell. There's Norden v. Gregory, which reversed a new trial based on a supposedly inadequate verdict. Moore v. Perry from this court reversed an additor. All these cases just reverse, remand for entry of judgment on the verdict. The only exception seems to be the fourth DCA, and it hasn't actually worked out that well because in one of their cases, Adams v. Saavedra, they remand for additional findings. They get a new order, it comes back to them, and they say, well, it still isn't supported by anything. You know, these are just buzzwords and catchwords with no substance in them. So it's not the common practice in this state, and it doesn't seem to be a good use of judicial resources either. And I just want to add that I think the record completely doesn't at all support the defense counsel's characterization of this case as showing a complete recovery, full functionality, having pain every day and having to work through it. The jury considered that it's interfering with his sleep, how it's going to affect, you know, not just the pain itself, but how it affects his quality of life, you know, the anguish of knowing that he's been through all his treatment and still hasn't gotten full relief. And for all these reasons, trial court did commit a clear abuse of discretion. We ask the court to reverse the order granting a new trial on future non-economic damages and remand for entry of judgment on the full verdict. Thank you.
All right, you have 4 minutes and 15 seconds.
A few points I hope to have time to make. First, there was no clear abuse of discretion here, and at least the remediator or new trial needs to be reversed. If this court feels otherwise, and to answer Your Honor's questions, the appropriate remedy, if the court believes that the trial court did not make appropriate findings, would be to remand to the trial court to make appropriate findings. We believe the trial court made appropriate findings. This is a shocking verdict. This amount of $247,000 for a future medical pain, for future pain and suffering award, when you may take some Advil and absolutely no medical treatment was recommended whatsoever. And again, I would ask the court to look at Dr. Greenberg's testimony to find this, is simply shocking. And to say that this isn't shocking or crazy is somewhat crazy. Again, if you look at page 19 of our answer brief and look at, or our initial brief, and look at the recovery that this man had, the fact that he may have to take over-the-counter medical medication, Advil and whatnot, does not support a $1.4 million award. To argue that the judge did not rely on these dollars, the $35,247, is simply not true, because that is the argument that we presented in our motion for a new trial that led to this order. So in granting the order, in granting the motion, the judge clearly saw these numbers as well as the evidence that was presented to him. If the court feels that a number needs to be specified and these items need to be specified, the appropriate thing to do would be to remand for additional.
When the trial judge said it's more than 5 times what it should be, or whatever exactly the phrase was.
Correct.
Did the judge identify where that number, where that calculation came from?
He did not. He did not in his order identify where that came from. We would suggest, again, it came from all the details given in our motion. And the judge was correct.
Well, it doesn't look like she cited in the record anything in her order that, supports her decision.
She did not cite anything.
She just used the
Math.
buzzwords,
She used the math, and I would suggest she used our math. And she saw that given that this man had had surgery, had a wonderful recovery after having gone
Well,
through
but the
terrible
jury
pain.
saw the man too. I mean, that's what juries do. I mean, they saw everybody. They heard the doctors, they saw him, they heard his testimony, and that's what they decided. I mean, that's what we let them
And
do.
a judge's job is to give a remitter where a verdict is so shocking that it is not supported by the
It seems to be in line
evidence.
with some of those other cases too. It's not so
And that's
far
one
out
of
of
the-
sight that it's
one of
not
the points
$500 million.
It's one of the points I'd like to make, Judge Jacobus, is that if you look at each of the cases, both from, and about 6 cases are cited by my opposition that are trial court decisions, to argue that this award for future pain and suffering is within a range of an appropriate award. Each and every one of those cases has an award for future medical expenses and had evidence, not just the plaintiff's own testimony that I had to take some Advil, but actual medical evidence that there would be future medical awards. And then there was an award of future medical expenses, and then an award of future pain and suffering. Those cases are each and every one distinguishable, because not that there has to be future medical expenses, we'll concede, there doesn't have to be future medical expenses to give some nominal amount of future pain and suffering. But every single case where a large future pain and suffering award was given, or anything that they're trying to argue is comparable or within the range, there was also an award of future medical damages and evidence of future medical damages. Here there is nothing whatsoever.
All right, your time is up. Thank you both, and